to promissory notes. So if somebody owes you money and you're holding onto a promissory note from them that they're going to pay you back, typically that's going to be a probate asset because there's nothing else in that promissory note that's directing where it goes when you die.
So things like your vehicles, or if there were a value or like plastic, something of value, then all of that would be settled.
Sometimes, right? So vehicles are one of those, well, as with most assets, they can go either way, right? Because there's a variety of different things that you can do to change buckets, to change things that were probate into non-probate and vice versa. A vehicle, for instance, especially again, if you're married, a lot of times you'll hold, and both of you are entitled to the vehicle. If you look up in the top left corner of the title certificate under the heading called brand, you might find a JTWROS label or designation, which again stands for joint tenant with right of survivorship. So if you see that on your title certificate as a legal matter, what that means is that when one of the account holders or one of the title holders dies, the ownership goes to the surviving account holder, right? Yes, JTWROS. Top left corner, there's a heading called brand on the title, on your title certificate. If you've paid off the car and you actually have the title, you can check there to see. Now that's the best scenario to have, is if you have that JTWROS in the top left corner, if your intention is to pass it to a spouse, say at your death, if you die first. There's a get to you just.
I mean, how many people have it don't know it, or how many people you have to put it on there?
Probably more the latter. Probably more the latter, that you'd have to know about it and request it in advance. I always just say, look, let's just start with a check to see what the title actually says. And if you have the title, meaning that there's no lien on the car, you already own it, okay, make an appointment with the DMV and go in and have them reissue the title and just request that they put the JTWROS on the certificate if that's what you want to do.
Okay. Say my husband has his name on the tractor, and should I get my name put on the title too? I mean, I thought this was community property state.
Oh, Lisa, right? Thank you for the great segue. Okay. So one of the other things that we want to consider in our framework when we're kind of setting things up to talk a little bit more robustly about probate and what it is and what all the steps are and all of that is this distinction between community property and separate property, right? Washington is one of a handful of states in the country that is a community property state, meaning that there is this overarching legal presumption here that if you're married and if you acquire any assets while you're married, that presumption is that it's owned 50-50 by the spouses, right? Now, there are exceptions to that, but that presumption is kind of our starting point. So in the case of the tractor, was the tractor acquired while you were married?
Oh, yeah.
Okay. So again, there's a presumption that even though he's the only one on title, you're still kind of in there, but it's a situation of like, how clear do you want to be about things, right? Because the more clarity that you can get in a plan, the better, right? Because you can start off with, okay, it's only his name on title, but we got it while we were married, so I have an interest too. Or why don't we just clarify this and get me on the title if we really want to treat it like community property? So we're just kind of removing that question altogether.
The biggest question is like, who's going to go first?
Sure.
And what if we, and go at the same time? We just want to make sure that
right.
we split everything with the daughters.
Mm-hmm.
And yeah.
Yeah.
But if only one of us goes, then I don't want to lose it if I'm the driver.
So that
I still want to
So again, starting kind of with that general community property presumption in Washington, adding a name onto title. So if there's a spouse whose name is not on a vehicle, adding that name to title, and then also throwing that JTWRS on the title. Let's see. Again, my hands are backwards. I'm thinking left. This is your left. Okay. So getting that JTWRS on title, that's going to be clarifying, but it's also going to be more convenient as well in terms of getting that vehicle transferred over to the surviving spouse. Otherwise, there's a question of, well, only his name was on title. Who are you? There's just more hoops you have to jump through, more hassle you have to deal with, versus if you have both names on title and there's that JTWRS, it's, hey, DMV, here's the title certificate, here's the death certificate, here's my identity. Please reissue the title in my name. Ellen, sorry, okay. Luis?
So if you put it in your will,
it
says, all my property that is my name goes to something.
Right.
That would be covering.
Yeah, that would cover that again. That if are we talking about vehicles specifically or just general?
Let's say vehicles, whatever you have,
right?
Some name only,
but
you're leaving, you be married, it's community property, so that way it will belong to the person who's driving.
Right. So if you have, so let's just say, let's go back to Lisa's scenario with the tractor. I'm liking this tractor, okay? So we have the tractor, it's just your husband's name on the tractor. We have the community property presumption, right? And your husband has a will and he says, I leave everything to Lisa if I die first. Then, okay, right? So that will is gonna help get title to the tractor in Lisa's name if they don't take other steps to get her name added to title.
So we should have separate wills.
Oh yes, everybody has his or her own will. There's no joint, well, you can do like a joint will, but I've only heard of them like academically. I've never actually seen one. They're not common practice. Everybody has his or her own will, right? Even if you're married, you have your own separate will, right?
Ours is pretty old, but I think we have separate ones.
Don't you? Time to update. Okay. All right, so let's jump in. We're moving right along with time here. So Washington probate law, you're typically going to find it in Title 11 of the Revised Code of Washington, right? So if you type in Washington legislature on Google, that should take you to the Washington legislature's main webpage. You can search the RCWs, the Revised Code of Washington, and you're looking for Title 11. So statutory laws in Washington are organized by title, chapter, section. So you're looking at Title 11, and then there are various chapters within Title 11 that address various things, and then you have even more specific sections. So that's kind of the breakdown of how those kind of the citation for the RCWs. Okay, we've kind of talked a little bit about this, but again, one of the big questions is, well, to probate or not to probate, right? And I think Judy, right? This is kind of getting to your question, like, when do you need to probate? When is it necessary? When is it not? So there are, again, as your starting point, assume that probate's going to be necessary, right? Assume that a probate's going to be necessary, and then work your way back from that to determine whether you can get out of it somehow. And so there are a number of different things that you can do, again, to take assets that would otherwise be probate assets and put them and shift them over into that non-probate bucket if the goal is to try to avoid probate, right? Now, how hard you should try to avoid probate is hopefully something we'll talk about a little bit more, because it's not typically the big scary monster that people make it out to be. But if that's an objective to try to shift things away from probate, then you can do things like using that JTWROS on a vehicle title certificate or on a bank account, right, with the spouse, or by making sure that you have beneficiary designations on accounts where you want those accounts to go to certain people. If you're married, you also have available what's called a community property agreement in the state of Washington, where you can use this agreement, and they're usually fairly short, 2 pages, where you can set out, okay, what all is our community property? Are we going to reinforce the presumption, or are we going to use this opportunity through this agreement to make some exceptions where maybe he had some property from before the marriage and she got an inheritance that they both want to keep separate from the joint community estate, right? So you can lay out, you can use that community property agreement to delineate, okay, everything we have is community property, or we're going to make these exceptions A, B, and C. Those are going to remain separate property of this spouse or that spouse. But then also in that community property agreement, you can have language that says that when the first spouse passes away, all the community property goes to the surviving spouse. And again, by having that community property agreement, you're taking some assets that might otherwise be in that probate bucket, you're picking them up, and you're setting them back down into that non-probate bucket, because the community property agreement spells out where the community property goes when the first spouse passes away. So that's a way, if you're married, that's the really, hello, welcome. What's your name?
Pamela.
Pamela, nice to have you here.
Thank you.
That can be a really shortcut way, if you're married, to get out of probate, is by having a community property agreement. Now, that being said, they're not for everybody, okay? This is not something where just because you're married, you absolutely should have a community property agreement, or at least there are some drawbacks depending on your situation and how complicated, how many assets you have. There are reasons why you might not want to have a community property agreement in place. So again, before you just jump the gun and decide that, yes, we're absolutely going to do this, get some professional help to make that determination of whether it's appropriate for your situation.
What would be a negative one?
A negative one would be if you have an estate that is of significant value, so that it's above the threshold for Washington estate tax. And so we're talking about 2 million or more. And you have to factor in real estate equity, life insurance policies, retirement accounts, bank accounts, the whole thing. It all gets thrown in together as far as trying, where you are in terms of that. It's actually 2,193,000 right now. But above that amount, there's Washington estate tax. If all you end up doing, so let's say there's a married couple, let's say they have a $3 million estate together. If all that happens is that one spouse transfers everything directly to the survivor through, say, a community property agreement, they lose out on an opportunity to shield a portion of that from estate tax when the second spouse dies, because they've given it directly to the spouse rather than using a tax savings trust. So that can be a drawback to using the community property agreement.